It's time to head out on the front porch on KFRM. Grab your favorite drink, sit back, relax, and enjoy the conversation on the front porch.
Hi, this is Kyle Bauer. My guest today on the Front Porch is Jeffrey Clayton. He's Executive Director of the American Bail Coalition. Jeff, first of all, let's explain what the American Bail Coalition is.
Absolutely. Thanks for having me on. The American Bail Coalition is a trade association of national insurance companies that underwrite criminal bail bondsmen throughout the United States, which we operate in 46 states. Since I've taken over, really the primary role of the coalition has been to protect the right to bail by sufficient sureties. And we can talk about a little bit about what that means. But what we're talking about is having the right to bail where a court affirmatively sets an amount of security that you can then post to get out of jail. And so that's kind of what I've been doing for the last 8 years.
Well, we're going to absolutely get into this in detail on how the process works, because it never occurred to me that bail bondsmen had their own insurance, if you will, to cover their risk. Let's talk about you. How does someone get in this line of work? Are you a lawyer?
I am. So to give you a little bit of background, I practiced law for a while and took a job working for two justices of the Colorado Supreme Court as their legislative representative. So I did that for quite some time and then decided to start my own lobbying firm. And one of my clients that had randomly called me one day were the bail bondsmen. And so that led to the National Insurance Corporation's kind of taking note that I was apparently doing a good job and gave me a call in the middle of what was, I would say, the high point of the end money bail movement, and asked me if I wanted to sort of defend the idea of monetary bail and bail by sufficient sureties on a national level. And that's how I got into it.
Well, I think most of us have never had to post bond, don't really understand the process, and we're going to get into that. But really, it sounds like to me you didn't set out to be in this industry. It just kind of evolved over time.
That's right. I mean, in my past life on the college debate team and then certainly working at it in the state courts, I've worked on the issue before, and I'm well familiar with sort of what the issues were. So when it happened, it wasn't sort of a surprise issue, and I thought it was really cool because I get to work on an issue that involved constitutional rights, history, economics. It's got a lot going for it as an issue to work on.
Now, is this something that you work on mainly in Washington, D.C., or is it only a state's issue?
Well, for your listening audience, there's a piece by John Oliver. There's one on bail that maybe we're not a big fan of, but the big one that they should watch is the one on state legislatures, and that's where we do most of our work. And state legislatures is where all the action is. That's where criminal law in the United States, by and large, is governed. And that's where all the law changes happen. And I believe there's something around 25,000 bills introduced at the state legislative level every year, which is a lot of action compared to the roughly 300 to 400 introduced at the federal level.
Do you have multiple staff that help you then? Because, my goodness, it's got to be far-flung, and you would have no idea where the hotbed is going to be necessarily ahead of time.
Well, these days people use, obviously tracking software has come a long way since I started. So generally a lot of time is spent reading legislation. And in the old days you would just sort of get a call and you would find out. A lot of times it would be too late. So there's that aspect of it. Do we have staff in every state? No. Do we have contractors in a lot of states? We do. And then there's also bail agent associations who hire lobbyists and attorneys, to defend them in court and also, to work on all this legislation. So it's kind of like a quilt. It's a patchwork of different things. Sometimes in small states like a Rhode Island or a Delaware, you spot a bill with a problem on it. You just have to send them a letter, and that amounts to what your lobbying turns out to be.
Yeah, I don't think a lot of people understand how much the process really does count on lobbyists for verbiage, to explain the entire process. A lot of times an issue seems quite black and white on the surface, but as people get more details out of it, there's a lot of unintended consequences that legislators don't necessarily know of initially.
That's absolutely right. You know, we used to have a saying in the Colorado Capitol that the state of Colorado has made it since 1876 without your bill. So, you know, you come out with a lot of great ideas, and then you realize a lot of them have been tried before, and we've kind of made it without that idea. And, you know, a lot of times you're satisfying different constituencies to try to come to something that's not, you know, a perfect thing that you want or that one of the interest groups want, but that can at least advance the ball forward a little bit in the direction that you think it should go.
I'll try not to be too disjointed on this. At some point, we want to explain to people how the cash bail process works. But for right now on the issue, the issue is some states are doing away with cash bond. If you're arrested, basically you are just turned loose on your own recognizance. Do I have that correct?
Yes, or I think the other thing that we're seeing is a new invention of this country that we didn't see until roughly 40 years ago, which was the concept that the government could deny bail. And we could expand that, which was allowed in the case of U.S. versus Salina in 1987. So that's really what we're talking about, is that we release people without security or as an alternative to bail, because we don't like the idea that somebody, you know, if they were rich, they could post this bond. We'll just deny bail altogether. And so that's kind of the two different things that are posited as alternatives to bail. And in my view on that is, I'd rather lose to release than detention policies, because I think they're evil and we can talk about why. But I'm in favor of more pretrial liberty with sort of as much accountability as we can find versus trying to expand the government's power to deny bail altogether.
Well, I think most of us, our background on bail or what we see on television, and let's hold that till the second segment on showing how that whole process works. But truly, there are a lot of people, hundreds of thousands of people that are held in jail until their speedy trial, and I use quotations around that, before they're proven to be guilty. And in some cases, they'll be held for many months, and then the charges are dropped. And so they weren't even charged, or they weren't even put on trial, and yet they were held because they couldn't make bail.
Yeah, I think that's right. But I think sort of we have to look at what the alternative system would be, and it would be one of detention. There would be a detention net, a pretrial detention net, and what would that look like? And I think monetary bail, the reason there is monetary bail is so that the public can challenge the government, so that third parties can challenge the government, and that's why it's an affirmative right. So, I appreciate that argument. I think it really cuts really hard on low-level charges where you're seeing people held on couple $100 bail on something, and you wonder whether that's worth it. You don't worry about it in places like the Los Angeles County Jail, where people have multiple felonies. The average defendant has 15 prior strikes, or something close to that, meaning convictions and prior failures to appear.
So, as we look at the bail process, or people that are trying to get bail, are you saying that some should definitely not be released on bail, or your past record, should that come into play, or does it, in all cases, should a person be allowed the opportunity to place bail?
Well, we're in favor of everybody being bailable, meaning that an appropriate bail that is argument in front of a judge as to what's sufficient sureties or not, and there's court precedent dating back, hundreds of years on that, and primarily its appearance. And I would say that the break in history also in the mid-'80s was to take into account your likelihood of future crime committing. and there's been a legal fight over that for the last generation as to whether that's a good idea or not, or whether we should leave it as to what it was throughout history, which is simply we need to set an amount of security as a means to guarantee somebody's appearance, not as a way to prevent future crime committing behavior.
The Constitution protects my right to a speedy trial, but it appears that bail was added later on by the states, or is that a federal right?
No, bail is a core right in the Bill of Rights, the doctrine of excessive bail. At the time, state constitutions, the Northwest Ordinance, which governed all territories, had right to bail by sufficient sureties. Right to bail by sufficient sureties was in federal statute until 1984. In other words, everybody had an affirmative guarantee that an amount had to be set and that the government can just move to detain somebody indefinitely without bail. Now, to talk about speedy trial, I think, the reality is that we've gotten sloppier on that. The average time to disposition on a federal criminal case in 1984 was 60 days, and now it's 365 days. So, bail becomes a lot more important when we're talking about sitting there for a year versus 2 months.
Yeah, which also brings up another question we'll take care of in one of the other segments is, as a bailsman, is your money tied up for 60 days or for 2 years? We'll talk about that here in just a little bit. We're visiting with Jeffrey Clayton. He's Executive Director of the American Bail Coalition. In the next segment, we're going to talk about how bail actually works in case I need it someday. Join us after the break for more On the Front Porch. Welcome back. My guest today is Jeff Clayton, and he is Executive Director of the American Bail Coalition. Jeff, I think to understand the bail process, we're just going to use me as an example. And when I'm arrested, and I haven't yet been arrested, I guess actually every time I get a traffic ticket, I think that's an arrest. But anyway, when I'm taken of an offense that I am arrested, taken to jail, how the process works. So let's assume I'm arrested by a county official and taken into the local district judge, I guess. Is that what happens?
Well, let's get into this. So we'll use a real example when I lived in Washington, D.C., and you will be my roommate, Brian, who unfortunately had an open can of beer and walked over to have a conversation with our neighbor about what we were going to do later in the day, only to be picked up by the Washington, D.C. Metropolitan Police Department and arrested and taken to jail. When you're taken to jail in this country, generally two things happen. One, you go before a judge, and the judge will set an amount of bail that you have to post or release you on your own recognizance, or the bail will be preset by a bail schedule. And that happens in Kansas quite a bit, where a judge has said, for this particular offense, let's call it felony theft, grade 4, the bail is set at $5,000.
Okay, excuse me then.
Yes.
If that's the case, then I don't have to appear before the judge, the sheriff, or whoever, the jailer, he can administer that?
Yeah, in many places that's known as a jailhouse bond schedule.
All right.
Meaning that, and that could be adjusted, I would point out, that you could later go in and say it should be reduced, or that conditions such as you can't leave the state, or certain standard conditions should be relieved. On the other hand, the prosecutor can move for an increase. So let's say you posted $5,000, he thinks you're going to flee and feels more security is needed, he could move for an increase.
Well, that's one thing that always occurred to me is like, okay, if I were to get arrested on a Friday night at 10 o'clock, so do I not even see a judge till the next Monday, or likely would that be a jailhouse bond that I could post without seeing the judge over the weekend?
Well, that's what makes this country great, is there's wide variety in terms of that. A lot of places, you could sit all weekend. Los Angeles County would be a good example, that if you're not going to bail on the schedule, you will be there for 2 days before you see a judge. State of Pennsylvania sets them pretty much all night. So, this could be this business where the judge is knocking on or the sheriff's knocking on the judge's door. Big metro areas set bail 24 hours a day. Mm-hmm. They have a duty judge that just does that. So it depends highly on where you are. The other interesting thing I'll point out is that rural jails are more efficient because there's just fewer people and there's less paperwork and nonsense to deal with. So that when bails are posted in rural areas, people are released faster than they are in metro areas where, like in New York City, you can post a bail and sit there for another 24 hours before the sheriff releases you.
Okay, so let's say the bail is set at $5,000, and I don't have $5,000. It has to be in cash, or how do you pay that?
Well, that's another variety that we have around the country. Generally, you have the option to go post cash, deposit it, which then could be refunded. Generally, if you're convicted, it's kept for fines and fees. In some places, you can do what's called unsecured. In other words, you're promising to pay if you forfeit, or the government can put a lien, et cetera, which really turns out to be pretty ineffective, but is allowed. And then the third option is to use a commercial bail bondsman, or what we would call a surety, to post a surety bond, which is essentially a contract of agreeing to forfeit a sum if the person doesn't perform. In this case, doesn't show up for court, and the bail bondsman doesn't bring them back. Then they have to pay the forfeited amount of the bond.
Okay, so my bond was $5,000, and I don't have $5,000. Well, okay, let's say I don't have it sitting around in my billfold. Let's say that I have to wait for the banks to open. Until the banks open, I have to sit in jail. I'm asking.
Well, you could call a bail bondsman in the 45 states we operate in, and so, or if you're land rich and you're cash poor, right? You have a lot of assets, but you don't have the actual money to put out X thousands of dollars, and for that, the bail bondsman can charge a premium to act as your what we would call a personal surety, which means they're guaranteeing the amount and your appearance. And so if you fail to appear, then the court can forfeit the bond and you're required to pay. The other thing is, commercial sureties, bail bondsmen generally have arrest powers. In some states, and I don't know what the rule is on Kansas, but in Colorado, a third party who's not a bail bondsman who posts a bond still has arrest powers. And so a lot of people don't realize that there is still sort of a citizen's arrest component to this that still exists from the old days.
Man, I would love to be the cop having to sort that out when they get called in on that deal. Because I put up old Pete's bond. He jumps bond. I go to his house, try to citizens arrest him. He gets upset. There's a big fight. The neighbors call the cops. And what a mess.
Well, then everybody ends up in jail, and we all need a new bail bond. Repeat the whole system over and over again, I suppose.
So when the bail bondsman posts my bail, they actually don't have to have that much money because they're bonded and registered with the legal system that they have the bond that can pay it?
That's correct. And in this country, there's sort of two ways that happens. And I can't remember. I think Kansas is mostly insurance-backed. So the bonds will be backed by national insurance companies, meaning if the bail bondsman doesn't make good on it and doesn't pay it, then the insurance company has to pay. Or in a lot of states, primarily in the South, people can put up cash or property and then write a certain percentage or ratio off of that. For example, Tennessee, a bail bondsman who puts up $1 million house can write $15 million in bail liability attached to that house.
Okay. So, yeah, because statistically the insurance company, not everybody's going to jump bail, so therefore that's enough surety to the insurance company.
Right, and certainly there could be different arguments about that from insurance companies versus people who underwrite themselves as to what would be appropriate.
Right, so the bail bondsman, then, he pays an annual fee for the insurance and or bonding, or does he pay per item?
Yeah, so generally it's per item, and there's a competitive marketplace for underwriting. So there's a competitive marketplace when a accused person tries to get bail. There's a competitive marketplace for bail bondsmen signing contracts with insurance companies as well. So that'll all depend on negotiations between bail agent and insurance companies as to what the rates would be. Generally speaking, the bail agents will make in excess of 90% of the premium dollars.
Okay, and let's talk about the premium. My bail, again, was $5,000. I don't want to sit in jail till the banks open on Monday, so I make a contract with a bail bondsman to pay the $5,000 and, well, actually just put up the surety for the $5,000. How much will I get charged?
Generally, we say 10%, but that's going to vary by the state as well. Some states are 15%. A lot of states, and I believe Kansas is one of them, allows bail agents to accept less upfront and then take payments over time, or to negotiate a fee less than 10%. So, in California, the fees are much lower than 10%, largely because the bond sizes are really high. So it will vary based on the state, but you can assume a 10% would be sort of in the range of what you could expect.
And then that bail bondsman, he has a fee he'll turn over to the insurance company that is about 10% that backs his bond.
Roughly, yeah, that'd be a good way to think about it.
Yeah, and so then that $500 that I pay to the bail bondsman, that's a fee. I never get that back.
That's right. And that, does a couple of things for you. A lot of places, that means the bail bondsman has to drive to the jail and post the bond. That saves your friend and family from having to do that. And then it's not subject to forfeiture. So, if you put up the whole $5,000 and you're going to plead guilty, you're going to lose that. So do you want to, put up the $500, not have to go to jail, and sort of have this other option? Most people tend to think that's a good option for them in many cases.
You're kidding. If I'm arrested and I am found guilty, I give up my entire bond, or only if that's the amount that I need to cover the fine?
Generally, states will keep the amount you owe, and fines, fees, costs, restitution, and surcharges.
They'll figure out a way to keep it, right?
A lot of these dollars. So you're basically, anytime you give your money to the state, that's a bad deal. So you have to take that into consideration. And the fact that if you kept your money and your trial goes on for 2 years, you could probably earn, some chunk of the bail fee on that.
Whereas if I only pay the $500 and I'm found guilty, then those things are negotiable, and the state doesn't have the money, so therefore I'm in a better negotiating position.
Right. Exactly, for waiver of fees, because there's not a deposit already there.
Very good. We're visiting with Jeffrey Clayton. He's the executive director of the American Bail Coalition. When we come back from the break, we'll be talking about why cash bail is controversial and why some people are trying to do away with it. Join us after the break for more On the Front Porch. Welcome back to On the Front Porch. My guest today is Jeff Clayton. He's executive director of the American Bail Coalition, which is a coalition of the insurance companies that bail bondsmen use. And we've been talking about the bail process, the bailing process, and how it's worked. Now we're going to talk about why it's become controversial. You have talked about a couple different dates over the last 80 years or 100 years that changed the law across the nation. Can you go back to those and give us a little more detail?
Absolutely. So just to kind of give you a basic idea of what bail is and what it was supposed to be, is a right to a personal surety, which means I'm putting up for you. I'm saying I'm going to guarantee an amount of money, and if you don't appear, that I'm going to forfeit, to make sure that you go to court and that we have this process move forward. And that's what right to bail by sufficient sureties means. Now, if you don't post that bail, and, bail, as the Supreme Court said, was an amount reasonably calculated to guarantee your appearance and no higher. And that's from Stack versus Boyle.
I'm sorry, Stack versus Boyle, in what year was that?
1951.
51.
And that was a case dealing with communists where the government wanted to deny bail because they said they were trying to overthrow the government. And the Supreme Court said, no, sufficient sureties means
everybody gets a chance.
Reasonably calculated, yes, right, to guarantee their appearance. And so, there's been criticism, and I'll talk about why there was, but in the federal system has gone down this let's not do money bail system. And at the time, we argued the same arguments that we're going to argue in a minute, which is we didn't think it was fair to poor people, that rich people could get out, that it was discriminatory, and that too many people were held pending trial. At the time, that was 24% of people in the federal system were held pending trial. 2% of those were for capital cases, so 2 out of the 100, and then the remaining 22%, to make the total of 24% were held on bails they couldn't post. So that was something we had to fix. So we came up with a new idea, which is we will deny bail to people that we think are dangerous, are going to flee, and then we don't have to use, quote, money as the deciding factor. So in the interim 40 years, the pretrial detention rate has gone up to 75%. And so it doesn't matter now if you're rich or poor. Everybody's detained. So 3 out of 4 are detained versus 1 out of 4. And so, that has been a driver of mass incarceration. And the Supreme Court decision which authorized this in 1987, U.S. versus Salerno, Justice Thurgood Marshall's dissent is one of the best ever. And he says this is a shortcut. We can just jail them now, and then we don't have to convict them. And I think that's right. I think that's what's happened. I think when you're being prosecuted by the federal government, you're going to plea because the average length of time, as I said, is a year versus 60 days then.
Yeah, and what my numbers were in the article I particularly picked out is pretrial detainees make up 70% of the jail population. And that's approximately 536,000 people across the United States.
Absolutely. And, the interesting thing about that is, the vast majority of those are people that are going to be held 30 days and longer. And so those are the cases that we have to move along. And that's why speedy trial is important. Most people are going to cycle out within a day or two. But the ones that really cost, the jail costs, 85% of jail costs, that at least by a study we learned in Michigan, are driven by 18% of defendants that stay 30 days and longer. So that's where the real opportunity is move these cases along and stop letting people just sit there.
Well, and in some cases, it's somebody with, I'll call it petty theft. I suppose that's a legal term that I'm using incorrectly, but a theft of something relatively small, and they can't post the bail, so they could literally sit in jail for a year, waiting to come to trial, and they haven't proven to be guilty yet at that point. In fact, there's a number of cases where the charges are dropped after several months from prosecution, and the person had sat in jail for 3, 4, 5, 6, 7, 8 months, and they weren't proven guilty of anything. And then they're turned loose, and the prosecutors don't have any skin in the game.
That's absolutely, we've seen that in a problem in misdemeanor cases primarily that last too long. But I would caution against saying they haven't been convicted of anything, because the average person that doesn't post a bail has 10 prior strikes. So, a combination of convictions and prior failures to appear. So it's not that they're innocent, so to speak, in the sense of pure innocence, but that doesn't excuse it. And that's what we see in these misdemeanor cases. That's why bail is a critical decision, and why I would argue speedy trial is probably even more important than bail. But I don't work on that.
Right. No, exactly right. And that's as I'm sitting here thinking, because we hear about this headline from time to time, and I assume it's correct, that the United States has more incarcerated people per capita, but I think maybe more incarcerated people than almost any other country in the world. Am I close on that number?
That's correct, and it's length. It's length of time. And let me give you another example that'll blow your mind. South Carolina. You want to go down to South Carolina and talk about felony bail and why it's important. Well, the average time to disposition is 660 days.
2 years. 2 years. 2 years
That's
to wait for your speedy trial.
That's law school. You can get through law school in 2 years. And while you're trying your felony sitting there. And so, yeah, it is a crucial decision. So I can see why people get mad. But it's not money bail that's the issue necessarily. It's how, what is the detention net and how long are people there? That's what we need to be talking about, more so than just money bail.
As you brought up the bail process and the courts absorbing that money with fees and fines and that sort of thing, do the court systems try to offset some of their costs by the, confiscation of bail? Or use. I'll use the word use of bail money and offsetting their costs.
Yeah, they do, and I think two abusers. The biggest abuser would be Indiana, that sets a 10% of the court bail, and we would argue many unnecessary cases in small amounts. Example, felony possession of firearm, 500 cash, but they know the person's either going to fail to show. They keep the cash, or the person shows up and they keep it. So that'll fund the court system. In New Orleans, they got busted for using the money for, new judicial furniture. One of our lobbyists calls it judicial cocaine, because once they get their hands onto the money, a lot of unnecessary bails are set. The bottom line is we need to, have no incentive for judges or anybody to set a high bail or not. Some states have bail forfeited money going to other purposes like public defenders, schools, first responder pensions, etc. All of which I think we need to get rid of. If it's forfeited, it should go to the general treasury, in my view, so that there's no perverse incentives in the bail process.
So if I'm running for the state legislature, the common thing, or the thing that lots of people like to run on, and even Congress, is I'm tough on crime. I mean, who doesn't want to elect somebody tough on crime? And it appears to me that a lot of times this legislation gets pushed through to prove that point, but it has unintended consequences.
Yeah, I think tough on crime has meant, in this last generation, long sentences. And so what we're talking about is incapacitation, which means we put these people over here, we take them out of society, and they can't commit a crime. That's good, but that doesn't get us where we need to go. Deterrence is where we need to go, which is certainty of getting caught. Swiftness of punishment is the key. The two keys from the Obama administration, the Bush administration, the Trump administration, any administration. Those are the two keys. So we need to bust people and punish them. And it doesn't matter if we send them into prison for 5 years or 10. In fact, our prison population is as old as it's ever been, but the reality is people age out of crime. So, there's...
excuse me, I'm sorry, just wait a second. What do you mean, people age out of crime? What do you mean by that?
Once people hit a certain age, their probability of committing crimes diminishes. And that's not universally true, but in general, it is true.
Is there a number that the industry accepts kind of as a general rule?
Well, when I represented the state probation department, it was sort of 35.
Okay.
Once they hit 35, they're kind of being a gangster days are either over or they're in for a life of crime. And so what we're seeing now in terms of the prison population is we sent people away so long that the prison population is getting older because people are staying in there longer. And, that's why we have the numbers we have. And the question is, if we busted them and sent them for 3 years and we busted more of them and sent them for 3 years, would that be more effective than busting one of them and sending them for 15 years.
And is there an accepted winning part of that argument?
Well, I don't know how politically you can sort through the hard on crime, soft on crime debate. It's just very difficult because what ends up happening is one side or the other cherry picks an issue, and we call it the Willie Horton and the reverse Willie Horton is what ends up happening. So yeah, it's hard to sell these policies or policy changes to the public, but the reality is you could be smarter on crime and harder on crime in a way that would work. And also you have to talk about prevention because of the value in stopping people from ever getting into a life of crime that we don't put enough money into.
We're going to go into more of that after the break. We're visiting with Jeff Clayton. He's Executive Director of the American Bail Coalition, and we'll be talking about the national ramifications of the Illinois Supreme Court's recent decision that ended cash bail in their state. So join us after the break for more On the Front Porch. Welcome back to On the Front Porch. My guest today is Jeffrey Clayton, Executive Director of the American Bail Coalition, which is the insurance company that backs the bonds on bail, or your local bail bondsman. There was headlines quite a bit in the news somewhat recently about the Illinois Supreme Court and their decision and affecting cash bail. They ended cash bail in Illinois. It appeared that that was an important milestone and or event in the industry.
Yeah, it was. Except, obviously we haven't, there are no commercial bail bondsmen in Illinois and haven't been since 1964. But it's important in the world of bail for two reasons. One, we thought if Illinois was going to have to get rid of bail, they would have to do what New Jersey did, which is get rid of it and then say, here's the new list of crimes for which a prosecutor could detain somebody without bail. So the Illinois legislature basically did what New Jersey did, but didn't change the Constitution to eliminate the right to money bail. So we assumed that the right to sufficient sureties would prevail. But the Illinois Supreme Court decided otherwise. So now the detention net in Illinois of who will stay in jail and who will not will be defined by the Illinois legislature. And so there's reason for concern because we have the list of charges for which detention can occur and for which detention can never occur. And interestingly, there's some sort of surprising examples of what that's going to be. But I mean, the bottom line is this is like putting 5 dice, in your hand and rolling them out into a bail system to see what things are going to turn out like. And the other glaring omission is the lack of funding. New Jersey, love them or hate them, when they decided they wanted to get rid of commercial bail bondsmen, they went to a system of government supervision primarily as a replacement, saying, hey, bail bondsmen aren't chasing them around. We need, electronic monitoring and government supervision. Illinois didn't do any of that. So it's really kind of an unknown as to what all this is going to turn into.
So if I'm arrested for shoplifting in Illinois, will I just be automatically turned loose?
Yes, and it's, to give you kind of even more of a flavor for it, felony theft's not on the list either. So it's not that you could just go misdemeanor shoplift. You can go felony shoplift, meaning steal thousands of dollars worth of merchandise, and you will be released on your own recognizance.
Now, that doesn't mean I'm not charged, and it doesn't mean I won't have to appear in court. It just means that I had no short-term ramifications of being arrested.
That's right. But I think the way to think about this is that the people that are going to be taking advantage of this are recidivists that judges don't trust. Because a judge would have trusted you, right, and released you on your own recognizance anyway. Now what's going to happen is the people that are going to take advantage are the ones that the judges wouldn't have released on their own recognizance, some of which maybe we could argue were erroneous, right? They should have been released. But the vast majority of those that the judges would have imposed the bail on are now going to get released. So in essence, the legislature has overruled judges. And, there's other glaring examples. You steal 5 firearms, for example, you cannot be detained. If you steal 6, a prosecutor can file on you and move for detention. So there's just a lot of legislative line drawing in here that's going to cause problems.
And so I get the impression you're saying that if we have 10 people, let's just stay with the shoplifting. We have 10 people that are arrested for that, and I'll make up the number. 9 of them maybe aren't, you use the word recidivistness, or is that the right word?
Recidivist, meaning they've done it a million times already.
9 of them wouldn't be, but 1 would, and that 1 is the one we really need to get, but we can't with the law the way it is now.
That's right, and here's why. Because the risk of the offender is determined by their background, not the crime they committed today. So, I may have stolen a car today, I may have gotten in a bar fight today, but it's, do I have 12 priors? Do I have engaged in a pattern of behavior that suggests that I'm a risk? And so that's what this law really takes away, because it's based on what the legislature thinks the charges are, the level of the charges that will lead to somebody being eligible for a prosecutor to file for detention and deny bail, which means they sit there the entire time.
It appears to me in my lifetime, the legislators have tried to take the judgment away from judges time and time again. In other words, mandatory sentencing. And what we're talking about here, is that just my perception, or do others have that as well?
Well, that's my view, although I was on a conservative radio show yesterday, and the host was arguing the other side, that the judges were too liberal and that legislatures were the ones that corrected them. There's a real balance. I think on this issue, it really is, and always has been, and that's why people don't like it, purely judicial discretion. And that's why people call imposing money bail that leads to detention sub rosa detention, because a judge could just say, I don't like you, and impose $100,000 and make up reasons that'll probably pass muster. So there's just a lot of wide discretion in that. But in this case, I think it's appropriate. I think it's better, because I think the judge looks at the person, hears from their attorney, and hears from the people. And that just, I think, is a better way to do it than saying we're going to take a grid and just pick charges. That just is too uncomfortable to me.
Well, in full disclosure, I'm on the judge nominating committee for our local judicial district, so I probably pay a little bit more attention than the average person does. And I have always thought, well, and I've only been on this about 10 years, but I kind of watch things, and I've always thought the process of allowing the judge to actually judge was a good system, and that our society was served well and the people were served well. Like you said, someone who's in the court, monthly, if you will, takes a different kind of consideration than somebody who's never been there before.
Absolutely. And, one of my good friends worked for Governor Ritter, and they used to do candidate interviews, and a candidate for a rural judgeship came in, and they asked him about his judicial temperament, and he responded, I have great judicial temperance. And they tried not to laugh, and thinking, well, at least he doesn't get drunk while he's going on the bench. But we do need good judges to make good decisions, and we have to trust that process. And you know what? We need better judges. We need to raise the pay, and we need to encourage better people. And I'm not to insult our current bench, but we need to increase the quality of judges in this country, and the quality of people that want to serve, for sure. And we need to trust that process.
On my 10 years on this nominating committee, every time there's an opening, I see less and less people apply. And I think it's exactly what you said, is that we need to raise the amount they are paid, and I don't think the ordinary person realizes how much pressure is on these folks, the workload that is on these folks, and then they're all lawyers, and so you have to replace that income they could make as a lawyer. And no, I agree completely, but I don't think the average person has much appreciation for the job that judges have.
Absolutely, and the pay is quite low, and it's more politicized now. I have a friend who is one of the most gifted judges in this state, whose name shall remain nameless, who probably could angle for higher office, but he basically just said it's gotten too political, and I like what I'm doing, and while I'm not, paid the greatest, the retirement's pretty good, and I'm just going to see this through. And, it's a major talent loss for this country. And I'm sure there's stories like that all over the country.
One last issue, we have about 2 minutes to talk about it, is many people, including myself, say that the judicial system is broken and it needs to be fixed. What sort of reforms would you suggest for our judicial system?
Well, on the criminal side, it has to be less of a machine and more individual consideration. And I think that just comes from having courtrooms that are public defenders appearing over and over and prosecutors appearing over and over, and the same people on the same day in the same machine. So I think that'd be one thing, is calendaring different attorneys and different theories and that sort of thing. But by and large, I think it's more resources. I hate to say that, but having represented the courts for 5 years, and probably it's more smarter application of resources. Courts are always behind the schedule and technology and things like that they need to do a better job on. So more resources, more efficiency, better judges, I think would be the top three.
Okay, well, that is Jeff Clayton. He's Executive Director of the American Bail Coalition. You've been listening to On the Front Porch. Thank you, Jeff.
Thank you.